Hello, and I would like to welcome you all to this West Midlands CR webinar on virtual hearings, virtual witnesses, and virtual reality in arbitration post-Covid-19. My name is Samir Shin, and I'm the chair of the West Midlands CR branch. For today's event, our speakers are the Honourable Barry Leon and Global Vice Chair of the CR, John Bassey. The Honourable Barry Leon is an independent arbitrator and mediator. Barry is a fellow of the Chartered Institute of Arbitrators and an International Mediation Institute certified mediator. He's experienced in arbitrating and mediating corporate and commercial, contract, shareholder and business breakup, intellectual property and technology, natural resources and construction disputes. Barry was the presiding judge of the Commercial Division, Eastern Caribbean Supreme Court in the territory of the Virgin Islands, known as the BVI Commercial Court, from 2015 to 2018. In that capacity, he has presided over a range of international commercial disputes involving parties from around the world, including shareholder and corporate disputes, insolvency matters, contractual disputes, fraud and asset recovery proceedings, judgment enforcement, and arbitration assistance and arbitral award enforcement. Our second speaker is John Bassey, who's a Global Vice President of the CR for 2021. He will be the Deputy President in 2022 and the Global President in 2023. He was called to the bar in England in 2003 and in Jamaica in 2004. In addition to being a member of the General Legal Council and chairman of its subcommittee with responsibility for the Compensation Fund. Mr. Bassey is also the treasurer of the Jamaican Bar Association. John is the founder of the Caribbean branch of the Chartered Institute of Arbitrators and its first chairman. He's also chairman of the Board of Dispute Resolution Foundation, which is the oldest ADR organisation in the region, having just celebrated 25 years of service to the industry. He's a certified tutor of the Chartered Institute of Arbitrators and a certified mediator of both the Supreme Court of Jamaica and Supreme Court of the State of Florida. This webinar is also supported by Arbitration Place. Arbitration Place has hosted over 25,000 hours of virtual and hybrid proceedings around the world since March 2020, averaging 12 virtual proceedings per day, ranging from the ordinary size proceedings to large complex proceedings. It uses an all-encompassing approach to client service in providing end-to-end support and services for hearings and mediations. It has also 40 virtual case managers being located in multiple jurisdictions and can provide service in most major languages. Arbitration Place's dedicated client service teams help clients plan some of the most complex virtual and hybrid proceedings on every continent. It is a founding member of the International Arbitration Centre Alliance with leading hearing centres in London and Singapore. Arbitration Place provides all the critical concierge level support needed for proceedings to run flawlessly, from court reporting services, document management, presentation support, interpretation, and all other services. Arbitration Place is represented today by Conference Manager Eric Tristan. In addition to our speakers, there will be a video at the end of the presentation from Arbitration Place regarding tips and techniques for effective virtual hearings. During the webinar, there will be an opportunity to ask questions using the Q&A function, and with these questions being answered at the end of the video. So on that note, may I please hand over to Barry Leon to start the presentation.
Thanks, Mayor. Let me begin by saying what we're going to talk about in the PowerPoint presentation that you're about to see with us. I will give an introduction, some background, and talk about where we are now in terms of virtual and hybrid proceedings. Then we'll go through something about the International Council for Commercial Arbitration country reports on the right to a physical hearing. And then we'll talk about various protocols that have been developed for virtual and hybrid hearings. After that, we'll talk about a couple of the institutional arbitration rules that deal with virtual proceedings or hybrid proceedings. And then John will talk a bit about the Chartered Institute of Arbitrators guidance note on remote e-resolution proceedings. We'll then talk about virtual witnesses, preparing hearing participants, practical tips for counsel and arbitrators, practical tips for effective conduct of virtual hearings, independent virtual case management providers, and then we will conclude and move into the video presentation that Samir mentioned. So let me begin by talking about where we are now. The COVID-19 pandemic impact on the global community has been, as all of us know at this point, immeasurable. People who have not fallen ill or been close to someone who has still have been seriously affected. There's been closures of workplaces and restrictions on normal consumer and other activities. Businesses have suffered interrupted supply chains and substantial financial challenges. Many businesses are facing risks or reality of insolvency even as we emerge from the pandemic in many parts of the world. Courts have operated with limited capacity in many jurisdictions, mostly virtually. And hearings have often been by video conference or in some cases, teleconference. Arbitration's procedural flexibility it has enabled it to meet the challenges somewhat better than the courts have been able to, and to address the obstacles that we've seen starting when the pandemic began about 15 months ago certainly in North America and Western Europe. Yet arbitrations have been affected by, among other things, many divergence and sometimes rapidly changing restrictions on travel and meetings in many different locations globally as the COVID-19 pandemic spread in waves and then mutated. Concerns, particularly initially, about the effectiveness of virtual hearings, especially virtual cross-examinations and time zone challenges. Concerns about not seeing the tribunal and witnesses in the same way, and concerns about the potential for cheating witnesses. Hearings moved to virtual slowly at first. Fairly quickly, the reality of the pandemic set in. The virtual option gained traction and wider acceptance. Case management conferences and proceedings without witnesses were most readily accepted as suitable for virtual. Fairly quickly, witness hearings were being done virtually too. Even many complex, multi-party, multi-location arbitration merits hearings with many witnesses, large numbers of documents, and participants in divergent time zones moved to virtual. Not all of them, but many of them. Many of the initial concerns were resolved by experience gained by all participants, by increased expertise developed by virtual hearing providers, by technological and procedural solutions to the concerns, by virtual hearing protocols and best practices. That's the past 15 months as I recall it, and I hope it takes us to where we are now. There are challenges that remain when one looks at both virtual and hybrid proceedings. The main one I found is time zone differences, although with accommodation, this concern is being reduced. Technological challenges, especially internet capabilities in some locations, yet virtual hearing providers are finding ways to ship equipment and get participants suitable locations. And then we have Zoom fatigue, yet the experience has enabled us to find ways to deal with that as well, with guidance from psychologists and others who have at least provided partial solutions. As vaccinations were developed and rolled out, arbitration began to look to its future. When the pandemic ends or is under control, will arbitration go back to the way it was? At this stage, arbitration appears to be looking to hybrid hearings for many cases. What are hybrid hearings? Hybrid hearings are partially physical in person and partially virtual. There's no standard model. Often, one has the tribunal together in one location, counsel teams together in other locations, and witnesses being wherever they are in the world, at their homes, their offices, hearing facilities, any place where they can get the suitable internet connection and facilities. It can be a mixture of all these arrangements depending on everyone's locations and other circumstances. But what it does not mean is one party appearing physically in person before the tribunal, nor does it mean only one party participating virtually. John, over to you.
Thank you. Good morning, good afternoon, good evening, and good night to all of our participants. Thank you very much for coming today. I'm going to speak a little bit about the ICCA and a particular aspect. Does a right to a physical hearing exist in international arbitration? Now, ICCA is the International Council for Commercial Arbitration. And around September 2020, a couple of editors, Hosking and Lalu, in collaboration with ICCA, formally launched a research project. It was called, Does a Right to a Physical Hearing Exist in International Arbitration? Now, the project arose from a need for reliable jurisdiction-specific information on this particular legal question. And one of the project's centerpieces was the sort of expressions of interest to participate as national reporters in a comparative survey. And the response was overwhelming. Hence, we are here today. 150 applications covering some 86 New York Convention jurisdictions were responding to the call. And the reports they were pleased to release their first national reports from 4 important convention jurisdictions. And they were Australia, Italy, Vietnam, and the United States. Now, the country reports on the ICCA websites, they differ in views on whether they have a right to oral hearing or the means of physical one. No such right in most modern law jurisdictions so far exists. The minority view that the right to physical hearing inferred in some jurisdictions are there. Next slide, please. And Switzerland actually states that the right to an oral hearing is excluded even when arbitration rules expressly recognize it. Now, the nuances concerning the power of arbitral tribunal to order a remote hearing despite parties' agreement to a physical one is important. In most jurisdictions, arbitral tribunals are bound by parties' agreement. And in some jurisdictions, parties' agreements to physical hearing could be superseded on the grounds of fairness and efficiency if the physical hearing is not possible due to the pandemic. Now, let's talk a little bit about protocols for virtual and hybrid hearings. In this particular protocol, there are several protocols, several organizations and institutions that have developed and published protocols for conducting virtual and hybrid hearings. Some focused on particular aspects of hearings or particular regions or types of regions. As the international arbitration world gained more experience with virtual and hybrid arbitrations, these have been improved and become more comprehensive and detailed. Today, we're going to focus on 4 protocols: the SEOUL Protocol, African Protocol, ICC Protocol, and the Abu Dhabi Global Markets Arbitration Center Protocol.
The SEOUL Protocol on video conferencing in international arbitration has sections which I've put up on the PowerPoint slide, which gives you, we're not going to go into the detail of the protocol, but it gives you an idea of the types of areas they cover, and you'll see that on the other protocols that we're going to touch on. So witness examination generally, video conferencing venue, observers, documents, technical requirements, test conferencing and audio conferencing backup, interpretation, recordings, and preparatory arrangements. The SEOUL protocol could not have come at a better time. It was released just as we were moving into the pandemic and starting to face the virtual world that we've experienced for the past 15 months. The focus of the protocol is on witness testimony. It's less directly applicable to full virtual arbitrations because they weren't prepared with that in mind. They're useful to enable arbitrations to proceed certainly in the early part when there wasn't any other similar guidance. The protocol acknowledges the risks of online technology in a private, often confidential process. The risks are real, but with the protocol's assistance, virtual participants were and are better prepared to address them. The protocol that we're going to take next is the African protocol, and I'll turn that over to John.
Thank you. Yes, the African protocol, I think it was instituted by the African Arbitration Academy, has 5 parts. The objective and the purpose of the protocol. Second part is the preliminary considerations, logistics and preparatory arrangements. And third, the virtual hearings and presentation of evidence. Fourthly, it looks at security and privacy considerations. And the 5th aspect of it is the hearing itself, infrastructure, and the technical standards. The protocol includes 6 annexes, providing detailed and specific guidance on technical standards, draft text agreements, and of course, minimum cybersecurity standards, the model pre-virtual hearing agreement, and the model virtual hearing clauses. Also provides for tribunal-issued cyber protocols and the witness oath. Yeah. It does provide practical guidance too. In some ways, it goes beyond just addressing the conduct of a virtual arbitration. There are additional details, recognition that many parties and lawyers with little arbitration experience are seeing arbitration as an alternative to delays in the national courts. So it takes that into consideration. And paragraph 3.26 advises that when allocating time during virtual hearings, the arbitral hearing shall set aside some time for housekeeping matters, objections, applications, and or other unexpected incidents or events. A simple but important point that may not occur to an inexperienced tribunal. You should also note that paragraph 2.16 notes that where any other parties do not have access to the technology, software, and equipment to be used for virtual hearings, parties may solicit arbitral institutions or other centers in Africa suitable to the parties that can offer their venues for conducting virtual hearings. So there's an element of collaboration too involved. Technology and connection services are often reliable and provide the necessary equipment, software, high quality internet connection, and minimal chance of signal interruptions. It also provides helpful guidance for those who may not realize that institutions often rent their facilities for these arbitrations that the institution is not administering. The protocol is specifically devoted to conducting virtual hearings and is quite basic. It does provide for the parties in 3.32. The parties may agree to utilize a cloud-based storage service to host all documents that are introduced in the virtual hearing and should take adequate steps to ensure that such storage and sensitive electronic documents are password protected and secure. That is from unlawful interception. Paragraph 4.4, which notes that the parties shall arrange for separate virtual meeting rooms during the virtual hearing, which can be used as a breakout room for parties and counsel. For arbitral tribunal deliberations and witnesses sequestration, the parties and the arbitral tribunal shall ensure that breakout rooms are secure and only accessible to those participants to whom the rooms are allocated. The protocol provides for pre-virtual hearing agreement as well. It addresses risk of party later challenging outcomes on grounds that the hearing was virtual, which I thought was very good. Ensures all participants explicitly agree to a virtual hearing in advance. Paragraph 2.31 states to dispense with frivolous challenges to arbitral awards. And sometimes we get them, but at the same time, there's a virtual hearing was held where there's no agreement between parties on the use of virtual hearings, and there are no provisions expressly regulating such hearings under the applicable procedural rules governing the arbitration. Parties shall, prior to the hearing and to the extent, enter into a pre-virtual agreement. So we can see the use and the need for a pre-virtual hearing agreement and how important it can be in our virtual environment. Next slide. The reality is that in many countries around the world, courts lack familiarity with arbitration. Courts also trust in suitability of virtual proceedings. Now, they also accordingly enter into a pre-virtual agreement is a decision for which many parties will ultimately be grateful if and when there are issues coming out of that virtual hearing. I go over to you, Barry.
Need to unmute myself. Okay, I'm unmuted. Thank you, Eric. I'm going to talk a bit about the ICC protocol. We just picked that as one example, and then John is going to talk about one that just came out literally a matter of days ago from Abu Dhabi. The ICC protocol, the first one is the main part of the checklist. And so it provides the items that we have listed on the slide here. First, a pre-hearing plan, scope, and logistics. Secondly, a section on technical issues, specifications, requirements, and support staff. Third, confidentiality, privacy, and security. Fourth, online etiquette and due process considerations. And fifth, presentation of evidence and examination of witnesses and experts. And then it has in Annex 2 suggested clauses for cyber protocols and procedural orders dealing with the organization of virtual hearings. We're not going to go through the details of those, but by this point, after some 15 months, there are a number of examples of those kinds of procedural order provisions, which are important to include. It's been a growing process as people learn from experience and develop new ideas of things that should be covered off. John, I'll turn it to you for the Abu Dhabi protocol.
Thank you, Barry. Okay, as Barry said, the Abu Dhabi Global Market Arbitration Centers protocol is literally days old. It came out in June 2021. Now, guiding principle, parties shall agree to conduct remote hearing in a manner that's firstly consistent with the principles of fairness, cooperation, and good faith, ensures enforceability and of any resulting arbitral award, and of course confidentiality, which is important. It also provides for the choice of platforms and service providers for remote hearing. It also speaks to participants, speakers, and attendees, and also the technical requirements. It will also refer to the use of platform for remote hearing, sitting days and hours, sequence of proceedings, timetable, confidentiality, and semi-remote hearing arrangements. Speak to the use of platform for remote hearing, electronic bundles of documents, which is important in today's environment, examination of facts and expert witnesses, presentations, demonstrations, and of course, list of issues and transcripts. Next slide.
We're on the next slide.
I think John's video is frozen.
Why don't I pick up where we were, which I think is at the beginning of this slide, just running through the provisions that the Abu Dhabi protocol has. John's freezing may be real, or it may be a demonstration of one of the things that can happen in a virtual hearing. We don't know. Let's see. So carrying on from where we were. The protocol provides for preparatory arrangements, modifications, hearing costs, location, and enforcement. It's an example of what I mentioned earlier, how there has been a growth of knowledge building on each of the protocols that have come before. And so you can see the Abu Dhabi protocol is quite comprehensive in terms of the matters that it deals with. The next topic, which I was scheduled to deal with, is the subject of the institutional rules that have also are a factor. So the protocol, and maybe these should have been talked about first, but all the institutions either had rules or have adopted rules that make it what word should I use? Make it acceptable. And so in effect, the parties have agreed to the use of virtual or hybrid proceedings. Some of the rules had it already, some were amended along the way, but certainly all the major institutions now have rules that make it clear. So the two that we've chosen are the new ICC arbitration rule, which is Article 26.1 on remote hearings. It grants arbitral tribunals the authority to decide following adequate consultation with the parties. And so I think each of these phrases is important, whether to hold a hearing in person, by video conference, telephone, or through other appropriate means of communication. Under the old rule in the ICC, there was some question as to whether a tribunal had the authority just because of the way the rule was worded. I think generally what we found is in most cases, tribunals are reluctant to order a virtual hearing over the objection of all the parties, although I've heard instances of that happening. But certainly there have been a number of instances where tribunals have ordered hearings where one of two parties is objecting. The second rule to talk about is the LCIA arbitration rule, Article 19, and it simply provides the tribunal has the discretion to order a virtual hearing or a combination of in-person and remote attendance. Now, there's still the question, of course, is whether jurisdictions will recognize an award where there has been call it a forced or an ordered virtual or hybrid proceeding. And that takes us back to the ICA survey of enforceability in different jurisdictions. If there's no sign of John returning, I will carry on with the Chartered Institute of Arbitrators guidance note on remote dispute resolution proceedings. So the Chartered Institute approached it in a somewhat different way and has made a helpful contribution to the world of virtual proceedings. This came out in early 2020, and it assists those involved in remote dispute resolution proceedings by, again, giving guidance on a number of the topics. The first part is technology and logistical matters, and it covers, the items listed here: preliminary considerations, venue, virtual proceedings, interpreters, witnesses, and experts, procedural documentation, and confidentiality and privacy concerns. So you'll see that there's certainly a similarity between the various protocols and the guidance note. But again, as I said earlier, a growing body of knowledge and expertise that has been developed as we've gained more experience. The second part provides legal matters and procedural arrangements, and then part 3 deals with institutional and ad hoc proceedings, which of course are somewhat different situations. And then there is an appendix, preliminary checklist, remote dispute resolution proceedings. And the topics it deals with are things that we've all become accustomed to now: distancing, There's institutional guidelines on remote proceedings, law and regulation on validity and enforcement of the enforceability of remote, recording the parties' agreement to remote, and we saw that in other protocols, particularly the African protocol that John spoke about, scheduling amendments to facilitate remote, and neutrals with practical familiarity with remote and the technology, which is another issue that certainly was important in the early part and led to, I think, all of us getting up the learning curve, and also the increased use of virtual hearing providers. Other topics it carries on with: online video audio conferencing platforms, cybersecurity, technical support for participants, platform procedure for transfer and storage of documents, list of attendees circulated and agreed. Important to know who is going to be participating, part of the planning and ensuring the integrity of the proceeding. The order of appearance and timeline will be circulated and agreed. And a list of documents to be presented by each party is distributed. And what we see, of course, is that all the things that we were used to in physical in-person hearings being adapted in some way to the virtual online situation. Electronic bundles prepared and timely distributed, attendees' physical rooms and the requirements for them to be enclosed, separated, headsets where possible. Attendees' physical rooms visible to all participants, no recording devices. And there will be, as you'll see it in protocols and in the provisions for procedural orders, arrangements as to the recording and access to it and use of it. Virtual breakout room procedures for deliberations and private caucusing. All the software, telephone, and internet connections being tested, sufficient audio-visual quality, and screen sharing available and tested. Let me turn next to away from the protocols and guidance and some of the things that need to be kept in mind, and some practical advice for the various participants in a virtual hearing. So first of all, we'll start with the virtual witnesses. Giving evidence virtually increasingly has become less contentious as arbitrators and counsel gain experience. And I found, listening to people in the arbitration world talk, counsel and arbitrators, it is much more common for people to say that they find it perfectly fine. Some will say it's even better. Others will be more hesitant. But I think there's generally been a much greater acceptance of having witnesses testify virtually and be cross-examined virtually. The view of the witnesses faced by the tribunal and examining counsel may be better than in many physical hearing rooms. Perhaps the most common concern that we've heard is that it's more difficult to assess a witness's credibility because of the limited, albeit direct, view of the witness. And I'm going to talk a bit more about that. A global study has revealed that diverse populations across 75 different countries share the belief that liars tend to avert their gaze, fidget, speak quickly, and shift their feet. I suspect that among the audience, if we were to take a poll, which we're not, a lot of people will say, yes, those are commonly accepted indicators of a witness who is not being truthful. Yet in some cultures, children are taught it is disrespectful to look someone directly in the eye. And I didn't realize how prevalent this phenomena was. Having spent time in the Caribbean, I know that is the situation here. It's the situation with Indigenous people in Canada. And I posted a comment on LinkedIn the other day in response to a webinar that's dealing with this particular topic. And I had a response from somebody in Africa saying, yes, it's the same thing where I grew up. Experts in lie and truth detection say there's no single nonverbal clue reliably signaling deception. To read a witness accurately, we need to amalgamate all sources of information: verbal, nonverbal, situational. We need to cross-reference those sources against their normal baseline and delve into the reason behind any concealed emotions. Most witnesses are not trying to deceive. And again, I read recently on LinkedIn in preparation for a promotion of a webinar, a quote from Lord Neuberger on that very topic. It's a webinar that Fox Williams is presenting very soon, within the next week or so. Many other factors contribute to the overall impression of a witness's credibility. In virtual hearings, we lose many, although not all, the channels of nonverbal communication. We do not see witnesses walking into the room or interacting with other participants. And often as an arbitrator or as a judge, you're conscious of watching what's going on in the room, how people are behaving, the whispering, the leaning over, their facial expressions. How helpful that is to assessing anything, often not, but sometimes you see smirks and reactions like that, which can only mean that the witness is or the prospective witness or the former witness is being contemptuous of whatever's going on. Video cameras often, as the case here, show the head only or head and shoulders view of the witness. We miss the hand and arm gestures. Social clues are missing, such as gaze and eye contact, even though if I look into the camera, I should be making eye contact with you. And if this were a hearing, you would be making eye contact back at me. Much, perhaps too much discussion in webinars and articles has been about witness cheating. The stated concerns include that a witness could have notes. There could be electronic communications to the witness from someone not in the room. Another person might be in the room off screen. I could add to that, the witness has other copies of documents or other than the ones that are being shown on the screen share. And there could be other ways of influencing or assisting the witness's testimony. But the reported incidents are rare, and usually those reporting it say it was obvious. Solutions exist to prevent witnesses from cheating. There's 360-degree cameras, so you see the whole room. There can be cameras in front and behind the witness, so you can see what is going on, what the witness has in front of him or her. You can have a prohibition on the witness having any other devices and electronic means of enforcing that. There can ensure that there's no other programs on the computer that the witness is using. There can be a neutral supervisor in the room when it's safe from a health perspective. And as mentioned a moment ago, you can block other communications into the room. Other cheating concerns exist. Witnesses could fake communication or connection issues when faced with a difficult question on cross-examination. And I've heard people talk about that. It's generally obvious when witnesses from the witness's conduct at the time and when the examination resumes. You see the tough question, you see the witness fumble and all of a sudden is having problems or disappears and then returns and is a new person. And those people have actually experienced that it's so obvious, and the attempt to cheat has failed miserably and undermined the witness's credibility. When there's an order excluding witnesses, you need to ensure that the witnesses cannot hear the audio for example, by being in the room where somebody else has the audio on, and that they don't see real-time transcripts, or indeed any transcripts that are produced until they've testified or otherwise complied with the order concerning witnesses. Interpretation works as well virtually as in a physical in-person hearing, and there's been lots of examples of that. Let me turn next to preparing hearing participants. So that is a broader topic than just witnesses. And we're going to hear more.
I'm back, Barry.
Welcome back. Sorry.
I am back. No, it's quite all right. Let me first thank you very much for filling in for me very briefly. And I thank the audience too for understanding. Barry actually spoke to one of the issues that we do have. Having a plan A, plan B, and sometimes a plan C when it comes to our internet connection. And we here in the Caribbean, well, I'm in Jamaica at the moment, sometimes we have issues with that particular connection, and it went down on us. In fact, it went down on me before we started. It happened again, and I'm actually on my cell phone now. So please bear with me if you see my image is not that clear, but the show must go on. Thank you very much for understanding. We're going to talk a bit about preparing hearing participants. As life would have it, optimize connections, test and assess computer hardware and internet capacity in advance from precise location with equipment that will be used. So the connection is optimized. I can tell you that in preparing for this particular webinar, we tested and tested and tested up to minutes before going on camera. And as you can see, sometimes it's always good to have a plan B. The camera view, adjust the angle and scope of the camera. Position your camera sufficiently distant away so the hand and arm gestures are viable, in addition to a clear headshot. As you can see now, I'm balancing the phone at the same time, but you're not going to see a clear headshot. That's why it's important to have your cameras angled correctly. Witnesses and counsel making submissions should look into the camera, not at other participants unless reviewing shared documents. It's very important you maximize the quality of participants' audio output and also the background. Participants, this is very useful, should appear against a plain background without distracting objects that create a visual clutter on the screen. There should be no virtual backgrounds for witnesses either, as that sometimes gets distorted and can be quite distracting. With respect to clothing, participants should plan to wear a plain shirt or a top. A striped shirt may cause visual blur. With respect to lighting, test your witnesses' lighting at the time of their due to testify. As you can imagine, lighting varies depending on whether it's high, noon, or late in the afternoon. Ensure the witnesses' facial features are fully visible, particularly if interpretation being used. If interpretation is being used. If you've got an interpreter there, it's very important you see the witness's face, because sometimes it can tell you quite a bit. The light source should not be visible on screen and should illuminate the background as well as the participant. Training and rehearsal for witnesses. Put a brief witness on the video platform and provide practice sessions in advance to familiarize witnesses with systems. It may be the first time that you actually been involved in something like this, so therefore it's only fair they understand what's going to take place. If possible, this is cute, have a backup for almost everything, especially if not in your office. Internet, hardware, lighting, and power. Ask yourself, if X goes down, what is my plan B? Over to Barry.
I was just going to say that consistent with what John was just advising, I keep a portable internet as well as my my main internet, and then as John has, I've got the backup of a mobile phone, actually the backup of 2 mobile phones, but there's some things that you don't have a backup for and some things that aren't expected, and it's actually astounding that the test yesterday with John, often I've gotten comfortable with webinars and we don't test, but yesterday we did a full test and everything was working perfectly. So it's the kind of situation that can occur during a hearing despite the best of preparations. And it's the redundancy that's important. So let me turn to practical tips for counsel and arbitrators. The easy one is make sure your cat or dog is not in the room or any other distracting person, animal, or factor. I was doing a webinar a couple of weeks ago, and it was where I live is perfectly quiet, except no sooner was I about to start to speak than somebody started with doing some repairs with a power saw. So you just never know. Sirens and all these other things sometimes just can't be controlled. But anticipate the unanticipated. Anticipate unexpected external sounds. Position your camera so that no one can tell what you're wearing below your waist. And we won't ask any of the participants here whether they are complying with that suggestion. Have a few books in the background or have a virtual background. But as one of the pointers said earlier, if you have a virtual background, you want to have a green screen so that you don't get that wavy hair when your person moves their head. What I have is just a plain curtain, which I find works well. And in terms of virtual backgrounds, you'll find that hearing protocols often prohibit them as a way to keep a level playing field. And certainly for witnesses, you don't have virtual backgrounds as was mentioned earlier. And it helps to have a second and sometimes a third computer monitor. You need the second to be able to look at documents. And sometimes people who are doing a lot of hearings find that a third monitor can be valuable to have. Consider using sticky notes or some other way of just putting key points in front of your eyes if you're looking into the camera. And that's a point that comes more from people doing webinars or giving talks than hearings. But sometimes it will be helpful to be able to look into the camera and be able to glance at a note in that way. Silence your phone as you would in a real hearing room. Mute your audio as and when required. And for hearings, generally the protocols will provide if you're not speaking, you should be muted. For counsel, if there's using the English expressions, a leader or a senior counsel and a junior, it's helpful to be in the same room physically, if that's possible, to enable the junior to share notes with a leader. I was in one early on watching a hearing where there was somebody charged with, there was a large client team in various different parts of the world, and they were sending in notes. There was one, or electronic messages. There was one person who was receiving those, collating them, and providing to the junior person, who then provided to the senior person any points that should be passed on to the person who's on his or her feet. The person speaking doesn't have time or the opportunity to ask for clarification or explanation. So just as in a real hearing, those notes need to be crystal clear, and it's more difficult when you're in a situation electronically. Next, we'll turn to practical tips for effective conduct of virtual hearings, and we'll go back to John for that one.
Thank you. Yes, practical tips for effective conduct of virtual hearings. We may want to consider having shorter days, especially if time zones are different. In other words, if somebody's having a hearing on the eastern side of the world as opposed to the western side. Clearly, there's going to be time differences, and we may need to figure out a shorter day in that particular case. More short breaks to reduce Zoom fatigue. I think that a lot of us have felt that from time to time. You feel zoomed out. And try not to look at yourself at the screen. It's distracting, and also it's said to be tiring. It makes sense to periodically look away from the screen to get your focus back. And also, in a 3-member tribunal, you need to agree on method of communicating. You may want to recess during a hearing to deliberate a point or speak quickly, or what you would normally do face-to-face is pass a note. How are you going to do that? Usually counsel teams need prearranged methods to communicate among themselves if they're in different locations. Sometimes the use of WhatsApp or other secure communication platforms. It's not a good idea to use the Zoom chat function. Sometimes mistakes happen. You can imagine that means sending it to everybody. Also, counsel needs methods to communicate with clients who may pass notes. You need to have a protocol for how counsel can object during an examination. That's really important. How do you just put your emoji hand up? How are you going to communicate an objection? What's the best way of dealing with it? What's fair? The arbitrator should explain to participants that tribunal will be working, looking at documents, taking notes, looking at second or third screens, and it doesn't mean that we're not paying attention. Also, virtual document presentation needs to be well planned and coordinated. Appropriate number of words on a screen are important, not too many. Smooth moving from page to page. It's better that a second person manage the documents, not the counsel who is speaking. Ideally, somebody who's had some sort of experience in that, or a specialist.
And that is a transition into what I'm going to talk about next, which is independent virtual case managers. I've come very strongly to believe in the value of having a independent virtual case manager to deal with all of the technology and all of the background things, so that the counsel and arbitrators aren't pivoting between their jobs of presenting or hearing the case and managing the technology platform. I think arbitration of almost any size requires those kind of services, unless it is so small that it just can't justify it from a cost perspective. And I would say that both for domestic and international arbitrations. The problem with trying to do two jobs means neither gets done well. And in a situation where clients are present, which will be most arbitrations, to see your counsel fussing with technology when you've engaged your counsel to be presenting your case effectively, or to see the person who's determining your case fussing with technology rather than paying attention, is quite disconcerting. It's unlikely that any arbitrator or counsel has the experience or expertise of an independent virtual case management provider. They do hearings daily and have that experience. If a problem arises, as it may do, and as we just saw, despite extensive preparation, having someone immediately available who has seen it all is essential. Penny wise and pound foolish is an expression that I think describes trying to do an arbitration any other way. If something goes wrong, the meter in the room with the combined hourly rates of the tribunal, counsel, the expert witnesses, and so forth, dwarfs instantly the costs of having engaged somebody to assist. And also, particularly in international arbitrations, there's limited time, even in virtual hearings, never mind in hybrid hearings. People's schedules have, as we all know, allowed a certain amount of time for the hearing, and that's it. And so if the hearing goes down, that time is being lost, and some may be recovered by longer days, but it could turn into be a real problem. Also, the experienced providers know how to avoid the common problems. We're going to hear more about that in the video presentation. Avoidance is key. John, do you want to conclude our presentation?
Precise replica of physical in person. However, it is worth noting that they both have their own advantages and disadvantages. I do believe that the virtual and the hybrid e-proceedings are here to stay for aspects of many arbitrations and other types of alternative dispute resolution mechanisms. It's also here to stay for litigation cases as well, especially for smaller cases. These techniques and protocols will become commonplace and an integral part of arbitration protocols as we emerge from the specter of the pandemic and it moves behind us. Hence, it's important for us to understand and master effectively the use of virtual proceedings for arbitration counsel and arbitrators. We cannot afford to wait a second longer. We need to act now and be prepared to be flexible for the future with respect to the evolving protocols as they relate to virtual proceedings. Thank you for listening to us.
Thank you.
So I think we're going to start our video from Arbitration Place. So Eric, could you show that up, please?
The first block to a successful virtual hearing is preparation. One must consider what factors make the hearing run smoothly and timely, or disorganized and untimely. Thinking carefully about virtual hearings and how they compare to and differ from traditional in-person hearings is crucial to be optimally effective in your virtual matter. While the hearing process may be the same, almost everything you do is at least slightly different than a physical in-person hearing, and the ways to be effective are at least slightly different too. Let's consider some virtual hearing versus in-person hearing parallels. For example, what happens if I don't prepare my hardware and software properly? In the worst cases, you are not present, and it would be like missing a physical in-person hearing. What happens if my documents are not properly prepared? If it were an in-person hearing, it would be like working with completely unorganized bundles or briefs of documents and not knowing how to find the documents you need. What happens if your witnesses are not properly prepared for the virtual hearing experience? It might mean that your witnesses will not present well and will be less confident and effective when answering questions because they are nervous or uncomfortable with the unfamiliar environment. These examples introduce the broad importance of preparation. So now me and some other members of our team will give you some specifics. In preparing your hardware and software, make sure you have a PC, laptop, or conferencing unit that's ready to properly interact with Zoom. While you can use a mobile device to audio call or use it separately in an emergency, your mobile device should not be your main way of participating in a hearing. You should download the Zoom software if you're using Zoom, as opposed to using the browser version. The browser version has reduced functionality. For clear and crisp audio, keep a set of headphones handy. Even if you're not using them, headphones are the fastest and easiest way to fix any audio issue that arises. Make sure you either have an extremely stable wireless internet connection or a hardwired internet connection. If you do not have stable wireless connection and can't reasonably set up a hardwired connection, consider purchasing or renting a Wi-Fi booster or going to a location that has a good internet connection. A dual video monitor setup is highly recommended for most hearings. The ability to see participants as well as documents is crucial for proper engagement. One example of usefulness is during the examination of a witness. It's through dual monitors that you can see a witness's body language and expressions while also seeing the documents most clearly.
A proper environment is a key part of preparation and will increase the effectiveness and professionalism of your screen appearance. Consider whether your location is set up and appropriate for your hearing. Make sure it has adequate space, adequate lighting, minimal potential for distraction, and is close enough to your router for stable internet connection if you're using a wireless internet connection. You should sit facing a window or other lighting source for best lighting. If you sit with the window behind you, others won't be able to see your face clearly. Try and choose a room that doesn't produce too much echo to others when you speak. Make sure that when you're in a hearing, you're not sitting too close to the camera so that everyone can see your face clearly. Also, wear neutral colored clothing against a plain background. When you're in a hearing, your background should not be distracting. However, if you do have a busy background, you can try a virtual background. One thing to note is that a virtual background works best when paired with a physical green screen. Without the green screen, you could have a situation where your face fades in and out of frame. If you're referring to or presenting documents in a virtual hearing, there are some considerations that you will want to know before you begin. One common mistake when presenting documents is sharing your entire screen. This can reveal your notifications and other such private things to those involved in the hearing. Smooth and effective screen sharing increases your professionalism and improves the experience of the virtual hearing for all parties involved. If you are using a service like OnCue or CaseLines, make sure you are comfortable managing those services while also sharing your screen on Zoom. It can be tricky without practice. You always have the option of retaining a third party to handle all of your screen sharing needs. Retaining a third party can take a significant load off and let you focus primarily on presenting your case.
Witness preparation can sometimes feel like an afterthought in the midst of managing the different aspects of hybrid and virtual hearings. We sometimes find that witnesses have poor technical setups or are unfamiliar with the technology or the special requests that the tribunal might make for them. For example, a witness can be asked to provide a 360-degree view of their surroundings with the door closed so that the tribunal can be sure that there are no people or communication gadgets in the room. Sometimes there's even a request for the witness to have 2 cameras, one in the front and one in the back, so that you're able to see the witness's surroundings at all times. As counsel or as an arbitrator, having a witness prepared for these instructions is crucial for the efficiency of a hearing. All those great suggestions that Michael and Heather spoke about earlier apply here too. You want to make sure that your witness has the right technology, knows how to interact with Zoom, is in a proper environment, and understands how to view the documents. Preparing a witness to testify under all of these complexities can make a real difference in the confidence and quality of your submissions. It's really in everyone's best interest. Redundancy planning is another important part of preparation. Try to have backup devices just in case your internet, hardware, lighting, and power, or physical location has a problem. I'll go over each aspect briefly. For internet, be familiar with how to hotspot off of your phone. For hardware, have a backup device ready to use. It's preferable to have another PC ready on hand, but in a real pinch, you can use your mobile device. For lighting and power, if you are connecting in an area where power failures or brownouts are not infrequent, make a reasonable effort to engage in your virtual hearing in a location with a backup generator. For your environment, Michael recommended earlier that you find a serene and private place, but we know that sometimes that's not possible, especially during the pandemic. If you know there's a tendency for your dog to barge into the room to say hello, or for a child to lovingly want to visit their mom in the middle of a high-stakes hearing, try and plan and prepare for this. If the worst happens, where your animals or children get the best of you, make sure you have that redundancy plan in mind. Turn off your video, mute your microphone, and ask your backup sitter to come in as soon as possible. That's just one example. When you're not retaining a third-party service to manage your virtual hearing, it's a great idea to have an overall redundancy plan set in case an individual cannot access the hearing room for whatever reason, or in case the hearing shuts down. Jasmine will talk about this in the next section, but setting expectations and provisions for unexpected situations can be a big relief when a problem arises.
In preparation for a virtual hearing, setting and agreeing on expectations and provisions is highly recommended. Boring as it is may be, we like to avoid surprises. If there are no agreed upon guidelines or no provisions for virtual conduct set up by the arbitral tribunal, consider raising it to the parties involved. If all parties are on the same page for the appropriate conduct, major problems can be avoided. There are various precedent procedural orders publicly available for virtual and hybrid hearings. We suggest that you take a look at those. In considering all of the steps of preparation, we assume you've been testing as you go. A final check is a great way to make sure things go expected on the day of the hearing. If you take one thing away from this video presentation, I hope it's that you should do your final test with the same setup and environment that you'll be using for the actual day of the hearing. This goes for your witnesses too, if applicable. Specifically, test whether your internet is stable enough to properly interact on a level that a hearing demands. This can look as technical as going to a website such as speedtest.net, or this can be as informal as asking a relative or a friend to have an hour-long chat with you on Zoom. You'll know that your internet isn't good enough if the call shuts down or if Zoom tells you that your internet connection is unstable. After a final test, on all of the relevant things my friends have presented to you, you should be good to go.
So you've listened to my friends and gone through all the appropriate steps of preparation. Bravo. But on the actual day of the hearing, while all of these steps of preparation greatly reduce your chances of running into problems, there's still a small chance that technology does what technology does. If you experience an issue with the platform, sound, video, or anything else related to the technology, the first troubleshooting technique is to log out and log back onto the platform. If that doesn't solve the issue, restarting your computer is the next best thing to do. Apart from this, rely on the protocols that the parties have agreed on in the case of technical mishap. Hopefully, Christina and Jasmine convince you that agreeing on some protocol is a great idea, whether it be postponing the hearing or using a dial-in option. When it comes to effective things to do on the day of the hearing, a few suggestions come to mind. Renaming yourself on Zoom to reflect both your proper name as well as which party you belong to adds some professionalism. Also, avoid using Zoom chat to communicate with your party or with other parties. In Zoom chat, there is a lot of potential for messages to be seen by unintended participants. Agree to use a different type of communication software for texting communication. Keeping yourself on mute when you are not speaking is a well-known but important technique to keep in mind. Keeping yourself on mute prevents echo, background noise, and has noticeable benefits. If you always forget to unmute when you re-engage, a neat feature is to hold spacebar while you speak. While muted, holding spacebar unmutes your microphone for only as long as you hold it. When we conduct hearings, we suggest hiding non-video participants to the parties. This just means that if there are members who don't have their cameras on, whether they be observers or simply out the door, their tile won't appear on Zoom. Some other viewing customizability that might be handy is that you can arrange video tiles by left-clicking and dragging them to their preferred spot. Know that you can't do this if you hide non-video participants. You can also pin individuals if you want to focus on them. Just hover over their tile and click on the ellipses that appear on the top right corner to find the feature. That concludes the main content in our accompanying video presentation for this webinar. You'll notice that we didn't provide technical instructions for each feature or strategy mentioned for brevity's sake. However, all of the mentioned points are researchable. For the curious viewer who wants to know about the handy miscellaneous tools that we couldn't get to in this presentation, those tools will be present on the last slide for your reference. We hope you found this advice helpful. Please hold on now as we turn over to the Q&A portion of this webinar.
Okay, so I'm glad to say that we've got quite a few questions, some good questions. So I think I'll just go from the top to the bottom. So the first from an anonymous attendee is how to be effective in terms of advocacy in an online arbitration. Please give tips in relation to examining witnesses, perhaps share the top mistakes made and how to avoid them.
Is John back with us? There he is. That was a bunch of questions rolled into one. Let's take it one at a time. So, or one piece at a time. I'm just trying to see the question there or maybe you can, Samir, just repeat it in pieces.
So how to be effective in terms of advocacy in an online arbitration? That's the first part of the question.
Well, neither John nor I well, I'm not doing any advocacy. John, I don't know if you are, but from having watched advocates and spoken to advocates, I think there's lots of wisdom on it. I think part of it is your presentation to the tribunal needs to be in bite-sized chunks, particularly if you're working with a document, whether it's a document in the case or your written submissions, a skeleton that you've got up on the screen share. So you can't overload, just like with PowerPoint, you can't overload too much at one time. And I've seen people be quite effective by being able to, with a team working together, the person controlling the screen share is putting up exactly the right document of whatever kind. I've also seen the reverse situation where it's a total jumble. I think another thing about being effective as an advocate is to speak as much as possible into the camera and forget about how you look, but you're communicating with the tribunal and with the witness. Obviously, you need to move your eyes around to be able to keep an eye on the tribunal as you would in a physical in-person situation. And of course, if you're examining a witness, you're going to be watching the witness. Those are some points. John, do you want to add to what I've suggested?
No, I think you've covered most of the major points and not too much to add there. No, I mean, it's a funny situation. We're all in a new learning curve right now. And all we can do is pretty much share what we experience as we experience it. So no, I think you've covered most of it, Barry.
And the second part of the question was to please give tips in relation to examining witnesses, perhaps share the top mistakes made and how to avoid them. Anything more you'd like to add?
I can probably add more from an arbitrator's perspective in terms of counsel trying to give evidence in chief, have his witness give evidence in chief for argument's sake. There's a lot of shuffling. When there's a lot of shuffling, it's distracting. And the witness, if they're not properly prepared, they're all over the place. And it leaves the arbitrator or the tribunal quite not knowing when they're coming or going. So I think preparation is critical in terms of your witness. Planning, having them realize that this is not a regular environment. It's not a face-to-face environment. So certain things, they need to look into the camera, they need to be calm, they need to do what they need to do to believe that they're actually speaking to themselves if necessary, so that it comes across as credible and also in order, cohesive.
Okay, thank you.
One thing, you know, I was talking earlier about the importance of using a independent technology or virtual hearing provider. One of the things that they will do, which you can't do in the same way, is work with each participant privately if necessary, members of the tribunal, witnesses, each counsel side in preparing them. They can help much easier than you can with your own witness in getting them ready for the virtual platform and dealing with all the things that we talked about, that the arbitration place video talked about. For witnesses, they've got it's a mixed blessing. They may be more comfortable in their situation than they would be in a real hearing room, but also they've got the added burden of managing whatever they need to manage in terms of giving their evidence. And so at one level, with some people, they may become too relaxed or too comfortable, but I think a worse situation is that they're not giving their best answer because they're concerned about dealing with the technology or trying to find the document they're being shown. Another problem for witnesses is if they've got the physical piece of paper in front of them, they can, if it's an agreement or a longer document, they'll remember there's some other part of the document that there's something they want to look at. You can't do that when the document's being shown to you on the screen without asking for it. So again, witnesses need to be prepped to be able to do those things and to be able to properly protect themselves or do the things that a witness should do to get fair treatment, and the tribunal as well will obviously step in to assist if a witness indicates that he or she needs that help.
Okay, thank you. Sorry, John, anything more to add?
I just want to add to what Barry had said too, and it's very important. I mean, as we start to develop in this e-world, if you will, that we all start sharing this sort of information. There's a number of parties who will not be able to afford a specialist or this sort of arrangement. But the more that parties begin to understand the nuances of the e-world, what they need to know, what they need to do, come to webinars like this, it's more the information shared that becomes more commonplace. And I'm hoping that we all get to that stage pretty quickly.
Okay, thank you. So move on to the next question from Anthony Gafford. He asks, do witnesses take an oath in virtual proceedings, and if so, who administers the oath?
That should be provided for in a procedural order. And I don't know that there's one answer, because I think you have to be conscious of the jurisdictional questions as to what is possible in the seat. And I guess I would also say in the place of enforcement, that you don't want to challenge to an award based on the fact that in the enforcing jurisdiction, the award wasn't administered. But essentially, obviously, the way it has to be done is virtually, with the witness having, if the witness is going to swear as opposed to affirm, having the necessary Bible or Quran to be able to to do it the way you would do it in a hearing room. But it should be provided for, and so it will remove any ability to challenge or significantly reduce it. But I would say eliminate it if there's been an agreed protocol, and so nobody can come along later and said, well, the oath taking wasn't as it should be, because it's been agreed and the party will be held to that agreement.
I agree with you, Barry. A procedural order is very much in order. How a witness is going to bind their own conscience is something that can be discussed prior to actually getting the witness there and agreed upon too. So it is something that we need to discuss and have an order in place prior to the actual hearing.
Okay, thank you. So next question from, hopefully I pronounced it right, Tancia Penn, QC. What, to your knowledge, is the experience to date with virtual hearings in the Caribbean post-COVID?
I mean, my experience with hearings in the Caribbean has been somewhat limited, other than case management conferences, which have run perfectly fine. But as far as I am aware from talking to people, and there's other people on the call from the Caribbean, if they've had a different experience, maybe they can just put something in the chat. But to the extent that arbitrations are going forward, whether with procedural conferences or merits hearings, they'd be done much the same as we've been talking about. Perhaps one thing to be conscious of is in some jurisdictions, the Caribbean being one of them, Canada being another, there's probably more ad hoc than institutional, certainly in some parts. And so it's necessary for the ad hoc tribunal to make sure that all the T's are crossed and I's are dotted when it comes to the things we're talking about in terms of protocols and embodying things in the procedural order.
Have you got anything further to add, John?
Yeah, well, my experience has been that pre-COVID, we found ourselves utilizing technology. It was more Skype technology, to be quite honest, pre-COVID. And then when COVID hit, Zoom took off, and I find the Caribbean, we've adapted quite well to it. That's why I do believe that we're not going to go back to where we were before. My experience has been, if I was to look across the board, not just arbitration, but mediations, prior to the COVID, we were probably, what, 80-20 in favor of face-to-face and how we're operated. I found out, as a result, now it's inversely proportionate now. It's now 80 online as opposed to 20 face-to-face. So I think that we adapted quite well. I think it's still evolving. I think that, like I keep saying, webinars like this, I learn a lot, more we can add to our game. And I do believe that it's here to stay.
I don't know that the audience got to see John's initial location, which failed him, but John, you've got a setup for video conferencing in your office, which has all the bells and whistles. And I think more and more people who are doing this, whether as counsel or as arbitrators, are going to have those kinds of setups.
Yeah. Yes, I think, if you recognize it, that you're going to be in this world, it makes sense to invest in a video conferencing system if you can afford to. They're actually reducing the prices more and more each year. But you know, you get yourself a good sound inside there, good camera, you're able to adjust your cameras, good screen and everything else, and it's a worthwhile investment. I'd encourage anybody who's an ADR, arbitrator, a litigator, once you're in that world, you should try and invest in it. Makes sense.
Okay, thank you. Next question from an anonymous attendee. Are there any specific protocols which are relied on in the Caribbean?
I didn't quite catch that.
Are there any specific protocols which are relied on in the Caribbean?
No, because we're bound by different, depending on the rules you agree on, you know. Once you've agreed on a set of rules, there are no overriding protocols that will, you know, other than, you know, you really can't force people to be in a face-to-face environment. So hybrids, you can't really enforce a hybrid hearing, but that's pretty much it.
Okay, I'll move on to the next question. So this is again from Anthony Gafour. And is it realistic for an arbitrator to conclude that a witness is not credible based on perceived non-verbal communication issues? And could this be a ground of challenge? Barry, would you like to take that one?
Sure, let me start with that. I mean, as I said in our presentation, and I'm going to give another pitch for the Fox Williams webinar that's coming up in a week or two with Lord Neuberger and a psychologist. I think I find as an arbitrator and found as a judge that assessing credibility is difficult, and unless it's, you know, a conflict between testimony that's shown to be incorrect based on documents put to the witness or witness admission, which you seldom would get. Or in places where there's depositions, discovery, prior examinations, those things. But even though you're in those situations, you know, there's credibility and there's credibility. There's the witness who's lying, and the witnesses, and most witnesses, I think, aren't intentionally lying. They're doing their best to be helpful. But there's all kinds of issues around, and these are getting much more attention now. The ICC Commission has something on it. Others have on witness memory. You know, the reality is hearings take place some period of time after the events. The UK and others will be in a better position to talk about than I am. There's new guidance from the court on preparation of witness statements. Guidance is probably the wrong word, but there's the whole question of witness credibility. The people who say I can tell if somebody is lying, I think, you know, they're fooling themselves. They're I think applying their own cultural, not just legal, but just cultural background to situations that may not be applicable. Let me just tell one short story, which I thought was interesting. And this goes back to when I was sitting as the commercial court judge in BVI. There was one case where there was a dispute between, well, it's public, but I won't give the names. But a prominent American business person, a prominent Hong Kong business person. And it all related to what took place in a particular conversation, a meeting. The American had written self-serving letter after self-serving letter or emails. The Chinese business person had not responded or written almost nothing in response. It was a cultural difference in how you deal with written communications, how much you have been trained to or feel it's important to or appropriate to write, document everything or write self-serving communication. So I think you've got to be very careful as an adjudicator in making judgment calls, and especially in your decisions and expressing views on people who you think aren't truthful or it affects their lives.
Okay, thank you. I'll move on to the next question. So this is from Tammy Pilgrim. Should the solution to prevent witness cheating form part of a trial or hearing order as a matter of course and apply across the board to avoid any perception of discrimination on the tribunal's part?
John, my answer would be yes.
Yeah, don't all jump at once. Yeah, of course. Yeah, I mean, yes. I mean, you start off how you aim to end. And at the beginning, you put an order in place to ensure not casting aspersions on either side, that certain things are understood and put in place and agreed upon. And that becomes part of your orders. Yes, answer your question.
I guess the only exception to that would be just like in a real hearing where something occurs and you go back to the tribunal and raise it. And, you saw the witness doing such and such during a break. Well, you wouldn't see it virtually, but that's the physical in-person example. You ask for a particular order in relation to that witness, but generally speaking, having a level playing field and making adjustments to those kinds of protocols on the fly in a virtual situation is much more difficult too. So better to have it agreed and sorted out, certainly for fact witnesses.
Okay, thank you. So the next question is from an anonymous attendee. It is how to become an international arbitrator, but if I may adjust that a little bit, may I ask Barry and John, how did you become international arbitrators? What tips from your experience would you give to sort of budding arbitrators to get into the industry?
For me, first and foremost, the education that I got from the Chartered Institute. I've been involved in ad hoc arbitrations prior to all of that at a young age, but the education that you can get from the Institute, especially their fellows course, if you get to their fellows course, it's great, it's fantastic. You are equipped with real life situations, and you are in fact equipped to actually do an international commercial arbitration. In terms of how do you start building your career, it's like anything else. You really have to start offering your services almost at times for free, right? Being with other arbitrators, being mentored by them, being prepared to do some of the grunt work, and aligning yourself with the Institute or your chapter wherever you are. Hopefully your chapter or your branch will align itself with organizations such as private sector organizations, particular bodies that require tribunal services. And that's a good source of, we can do that for you. And it grows from there. And of course, you link with other branches across the world and they get to know you. Teaching is another way. We have myself and former Global President Jeffrey Elkinson. We have actually tutored on almost every continent in the world. And we've had some good times, got lost in some airports or what have you. And we've made a lot of good friends in different parts of the world. And by that, people know your name. They say, oh yeah, I remember that guy. Perhaps we ought to use him. And even more so in this virtual environment. That's how it's worked for me.
Now, I just add, without knowing the circumstances of the anonymous attendee who asked the question, it depending on your circumstances, there may be some other techniques. So for example, if you're a senior counsel, you're going to have a reputation and people will know you and it may be easier for them to start thinking about you once you've hung your shingle out as an arbitrator. If you're a more junior person, I think what you want to be doing is building your career as an advocate or your reputation as an advocate in arbitration. And I wouldn't draw this bright line between domestic and international for people trying to become an international arbitrator. I think commercial arbitration, if done in an international way domestically, as it should be, you're going to start to develop that same reputation. And if you're in an area such as the Caribbean, and we have a number of people from the Caribbean, or an area where there's a lot of countries, smaller countries, the trade between them is international. The business between them is international. And so a regional dispute is international. It may not be the dispute between countries in different parts of the world, but it's international. In Canada, we found that because so many Canadian companies may be subsidiaries of an American or some other global companies, so the difference between whether it's international or domestic may just turn on which party signed the contract, but the reality is the underlying business situation is very much international. So I don't know if that's helpful to your circumstances. People appoint as arbitrators, and this isn't just for people starting out, people who they know their reputation, have seen. And so it's just getting on a roster isn't going to do the trick. It's writing, speaking, all the things that people do to build their reputations.
Okay, thank you. Thank you for good answers.
One more thing I would add is if you've got a niche area, whether it's technology, whether it's construction, obviously that, that background expertise, your prior life or something that you've worked in, whether as counsel or whether you're an arbitrator coming to it without a legal background, that's obviously the way you've got a competitive advantage.
Okay, thank you. So next question from Ashish. What are the platforms through which we can participate in virtual arbitration? And if I may add to that, have you seen the use or increasing use of actual specialist platforms for arbitration compared to just say Zoom or Teams?
Yeah, I have seen quite a number of different formats, and some of them are very good actually. They provide for you different breakout rooms. They allow you to put on different videos, if you will, almost do the preliminary actions. And I find them to be quite good. You got to search around though to see what's out there, but I have found one that seems to be pretty
good. As time goes on, the providers of these platforms will and have been to some small degree customizing their platforms or to fit the particular use, and so there are adaptations that eventually they'll get around to implementing that will make the screen look more like a hearing room or a courtroom. We'll just make it more functional for this use. I think the experience that I've heard from many of the providers is that by far the majority choice is Zoom, and it has a functionality, and we're talking about the high-end Zoom, not the free Zoom, a functionality, a security, and so forth now that, and just familiarity that people have. I find when I go on new platforms, even if it's just for a conference, I'm struggling a bit. Most people are quite comfortable with Zoom, and at least I found it has a more comfortable functionality than some of the others.
Next question from Anthony Gafour again. How would you rule on the issue of one party requesting a virtual hearing and the other preferring an in-person hearing?
Well, Judge Gafour knows that a wise arbitrator judge never prejudges. I think, though, that it depends on the circumstances, and I don't think it's a question of preference. The experience has been that if one party is objecting, I wouldn't take it at face value. I'd inquire into the reasons, and I think the decisions that have come out, both from courts and tribunals, to the extent I've heard of them, have been that it's not just an open and shut case. You take account of all the factors. What are the reasons why the party doesn't want to have a virtual hearing or is leaning? So there's one I'm involved with, and both parties agreed not to wait to have a physical in-person hearing because of time zone concerns. But sometimes like in any proceeding, somebody's trying to delay it. And if they don't have a good reason, that would be certainly one circumstance. The other thing is, at least early on, it was a lack of familiarity. And some arbitrators have arranged or suggested that the parties arrange to have a demonstration and to get more comfortable with how a virtual platform works. And I know in some instances that has made people more comfortable. That was early on, but there's probably some people who are still hesitant for that reason, just a lack of experience with it.
Okay, thank you. I think John may be required to leave quite soon, so I just want to, before we answer the two last questions, I just want to thank John for his time, certainly in preparation and providing participating in the speech. So just on the behalf of the West Midlands branch, thank you, John, to have such a distinguished guest in one of our events. So if I go to the penultimate question, please, hopefully I pronounce his name correctly. Apologies if I don't. Leonor Aguera Jacquemet. So from your experience, how do you suggest to handle issues related to translation stroke interpreting in a virtual context?
John, I haven't done it. Have you had those situations? And Eric may want to reappear and say something, but my understanding is that at least with an independent provider, they just connect up the interpretation and it flows seamlessly. Eric, is there anything you can add on it?
So it is dependent on what platform the hearing is happening on. And I'm not advocating for Zoom. We are platform agnostic, but if you are on Zoom, it's a very simple feature that they have embedded into the program. And there are other platforms as well that focus specifically on matters that need to handle interpretation. But it is a very simple process. All you need to do is you need to contact the interpreters, and once they join the Zoom call, all you need to do is turn on interpretation and you submit them as the interpreters, and members can just join the channel that they want to hear the language in.
Yeah, there are some providers that have that feature. You just click on whatever language it is you want and they'll provide a translation and a certificate to go along with it as well.
Okay, and the final question from Elizabeth Solomon. In a situation of asymmetric internet access or technology between parties in a virtual arbitration, is the lowest common denominator approach appropriate despite the requirements of the various protocols, meaning opting to use a lower level of technology to ensure fairness?
Well, I think that you, as an arbitrator, you don't want to put anybody at an inherent disadvantage. So I guess you take each one as it comes along, but I can understand the argument for that. Like Barry said, you don't want to prejudge anything. You want to figure out what's happening on the day of or prior to it. Barry?
Yeah, no, I mean, you do want to level the playing field. I've heard some situations, and this is a different situation, where because of COVID restrictions, one side could assemble together in one place, the other side couldn't. They had to be from home. In that case, I think the tribunal said that doesn't matter. They weren't going to force the people who could be together not to be together. But I think this is one of the important issues in terms of fairness, and whether it's a physical in-person hearing or another hearing, there's a need to treat both parties equitably and ensure a fair hearing. I guess my inherent approach would be to not start by saying we're going to go to the lowest common denominator, but see if it's possible to up the lowest common denominator by leveling the playing field. And that could involve suggesting to the parties, other ways that they could get access to better internet, and the internet seems to be the big question. Or in some cases, I know that equipment can be for bigger hearings shipped in to almost any place in the world. There was one hearing in Mexico where in a location where there weren't good options. They looked at lawyers' offices and finally concluded that one of the bigger hotels would provide the best answer for internet. So I think that the starting point would be to try to solve the problems for the lowest common denominator person, but ultimately to try to conduct a hearing that is fair to both parties.
Okay, so I think that's all the questions. So I just want to repeat again my thanks to the Honourable Barry Leon and CARB's Global Vice President John Bassey for an excellent talk and providing the answers to the questions, and also to Arbitration Place with regards to their tips and techniques, and also Rick's help in organising this meeting.
Just before we leave, there were in the chat earlier on, there were some people asking about the video of this and about the PowerPoint slides, and I had responded to at least some of the questions saying that the plan is to post the video in a few locations, and somebody asked whether we can send out the PowerPoint slides to everybody who's registered. I assume that's possible, but at least let's say to the people who were interested, we've taken on board those things, and we'll do our best to get both the recording and the PowerPoint slides to those people who want to see them.
Yes, definitely. And I want to thank all the delegates who actually dialed in, and we had a fairly good turnout. In regards to the West Midlands branch, we're planning to do some future events, and we haven't really decided whether we want to do virtual or in person on NEC3 contracts, a mediation workshop, potentially an event on disputing manufacturing engineering, and a construction adjudication workshop. So I'll just write my email address if anybody's interested in such events, just so I can keep people informed when we do run those events. And again, there's a lot of interest around the world, and that's one of the benefits of the virtual world these days. I'm more likely to go down the virtual route rather than an in-person event. So again,
it was great, Samir, to see people put up their locations in the chat, and we do have people from all around the world.
I think from probably at least 4 or 5 continents. So that's I'd say. I think I certainly felt COVID has been challenging in terms of work, but one of the sort of like silver linings of the cloud is the sort of the more connectivity across, my peers in the Institute and other organisations in sharing ideas. So hopefully that should continue, hopefully when everyone's vaccinated. So on that note, I'll thank everybody again, and hope to see you in one of our next events. Thank you. Bye.
Bye.
Thanks, everyone.